proceed.
Judith Baird for the Commission for Lawyer Discipline. As a preliminary matter, we had submitted objections to the exhibits that Mr. Gifford attached to his answer, as well as to some of the hearsay statements in his answer, and would like to know if you've ruled on those.
Since this is a hearing, they've been not offered as evidence. If they're offered, then you can reassert those objections. But, you know, this isn't a motion, so, you know, if they're offered, then we'll rule on the objections at that time.
Okay. This is a reciprocal disciplinary action brought pursuant to Part 9 of the Texas Rules of Disciplinary Conduct, based on discipline imposed upon Eric Paul Gifford in the state of Florida for misconduct, in where he was disbarred. The petition for reciprocal discipline was filed with the board on September the 6th, 2012, and an order to show cause was issued by the board on September the 7th. We're requiring the respondent to show cause within 30 days why identical discipline should not be imposed in Texas. The original proof of service was filed with BODA on October the 9th, 2012. On June the 16th, 2011, a complaint was filed in the Supreme Court of Florida in the matter styled the Florida Bar Complainant versus Eric P. Gifford Respondent, cause number SC 111182, TFB file number 2011 3122005A. On or about September the 12th, 2011, a report of referee was filed with the Supreme Court of Florida in the same matter. On February 20th, 2012, an order was filed with the Supreme Court of Florida in the matter styled Florida Bar Complainant versus Eric P. Gifford that states in pertinent part as follows: the uncontested report of the referee is approved and respondent is disbarred. The report of the referee found that the respondent admitted that he committed an act that was unlawful and contrary to the honesty of justice, failed to comply with the bar rules, Florida bar rules regarding trust accounts, committed a criminal act that reflected adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer, engaged in conduct involving dishonesty, fraud, deceit, or misrepresentation, failed to comply with trust accounting requirements, failed to hold in trust separate from his own property, funds and property of clients or third person that were in his possession, and failed to hold in trust, applying only to that purpose, money or property entrusted to him for a specific purpose. A finding of misconduct in another jurisdiction is conclusive for the purpose of this disciplinary proceeding. Under 9.03, the discipline to be imposed in this reciprocal proceeding shall be identical to the extent possible to that imposed in Florida, unless the respondent can prove by clear and convincing evidence one of the enumerated facts or defenses in 9.04. In his answer, he claims that the misconduct that was imposed in Florida warrants a substantially different discipline in Texas, and that his disbarment in Texas would result in a grave injustice. He cannot meet the burden for either of those defenses. Where Mr. Gifford stole money from a mentally retarded individual who was also legally blind, and, as in Texas, the referee in Florida considered the testimony and credibility of witnesses and weighed both aggravating and mitigating factors in making the recommendations in their report. Further, Mr. Gifford had an opportunity to contest that report to the Supreme Court of Florida before they entered the order disbarring him, and he did not do so. The disciplinary system is charged with the responsibility to protect the public and uphold the integrity of our profession. At the end of this hearing, the Commission will request that this board enter an order imposing identical discipline to that Florida imposed on Mr. Gifford and disbar him. Thank you.
Mr. Berry, can I ask you something before you get too far away?
Certainly.
And Mr. Gifford, I'll give you a heads up. I'm going to be interested in your response to what I'm about to ask her also when it's your turn. My question is, are we certain that disbarment is the identical discipline? And I'll tell you why I ask. In the Supreme Court order, it does say respondent is disbarred, absolutely.
Yes.
But it says the uncontested report of the referee is approved and respondent is disbarred. And then you go over to the referee report and it says disbarment for 5 years, the minimum amount of time authorized by the rules. And so I'm wondering, in the way we use the word in Texas, has he really been disbarred or has he only been suspended for 5 years as we would use the term?
He has been disbarred. In order to be reinstated, he does have to reapply and take the bar exam.
So it'd be analogous to our situation where you can reapply after
5 years, correct. They also have a provision where they can disbar without the possibility of reinstatement. So that's, I think, why they make that distinction, and he can probably speak to that, but that's my understanding.
So your view is disbarment, as we use the term, is the identical discipline, and as with any disbarment, he can come back in after 5 years and seek reinstatement.
Absolutely.
Any other questions right now? Okay.
I'll do that in my case in chief. That was just.
Mr. Gifford?
Thank you. And just by way of question, I'm not familiar with procedures. Is this opening statement or?
On these, we're pretty lax. If y'all want to do opening statements, go ahead.
Well, I just was
Yeah.
curious. I mean, I was prepared to put a case in chief on and then make argument. There was a combination of that here, and I just want to make sure I don't waste the board's time. I said when I indicated it'd be 15 minutes.
Yeah, if you want to make an opening statement, that's fine. If you just want to cut to the chase.
I think that would be in everyone's best
Yeah.
interest.
I don't think
I'm not here to take an inordinate amount of time.
Okay.
But let me go do that. If it's okay with the bar council, I'll put on my case, and then if we're making an argument afterwards, I can.
Well, I think if
I need to put on my.
yeah, she needs to put on her case
well,
first.
I'll defer then. And
So go ahead and.
Okay. Then I'll go ahead and make an opening statement.
Now, just a point of clarification, we've read the pleadings, and I think we understand the positions of the
Understand.
parties and the rules, so I don't think there's any harm. Just cut to the chase.
Okay. At this time, I'd like to offer petitioner's exhibit. May I approach?
Yes.
Exhibit number 1 is a certified copy of the complaint filed in the Supreme Court of Florida in the matter of Style Florida Bar. Complainant versus Eric P. Gifford, respondent. Case number SC 11-1182, TFB file number 2011 3122005A. Exhibit number 2 is a certified copy of the report of the referee filed in the Supreme Court of Florida in the matter. And exhibit number 3 is a certified copy of the order filed in the Supreme Court of Florida. And exhibit number 4 is the original certificate of Blake Hawthorne, clerk of the Supreme Court, dated September the 28th, 2012, that shows that the respondent is licensed and currently authorized to practice law in the state of Texas. We seek disbarment as reciprocal discipline. And at this time, we'll waive our argument until.
Any objections to exhibits 1 through 4?
No, I reviewed the exhibits. I have no objections.
Okay, 1 through 4 are admitted.
Okay, thank you.
Mr. Berry is rested. Go ahead and put on your
Yes, thank you.
case, Mr. Gifford.
Mr. Chairman, member of the board. My name is Eric Gifford. I represent myself pro se in this matter. As Mr. Berry indicated, I previously submitted an answer, and I apologize for the format. I was not exactly sure of the procedures. I have admitted to all of the allegations in the petition brought by the State Bar. The only thing I think I asked an opportunity to have was to come here and to be here present and in person. I feel like my actions require me to follow through all the consequences, including standing here before you, so that I at least get to meet you face to face, stand in this building, which I've never had the opportunity to do so. It is with great regret that I'm here under these circumstances. With that, though, I did promise to be brief, and I will. I understand the challenge that I face, and I really just wanted an opportunity to be able to present to you who I am in the small amount of time that I have. I've offered, along with my answer, a number of exhibits, and I acknowledge the motion by the bar. I'm asking to admit exhibits 2, 3, 4, 7 of those exhibits into evidence absent objection by the counsel for the bar. And those are in the index. One is an affidavit. Second is a letter from me to my law firm, former law firm. The fourth is a resume prepared by me during the Florida bar proceedings. And the last exhibit, 7, is a composite exhibit listing a number of military awards that I received from 1991 through 2002.
And we would object to those exhibits.
Are your objections the same as contained in your filed pleading?
They are.
Overrule the objections and admit the evidence.
Thank you. And I'll also ask, attached to my binder were exhibits 10 and 11 and 14. Those are copies of cases both in Florida and Texas. I'm not offering those into evidence, but I provided those to the board. I'm asking basically, if necessary, you take judicial notice under Rule 201 so that you have those available to you. That's the basis I was intending to offer them, not as evidence in the case in chief. I hope you understand that. I didn't know that the counsel for the bar had objection to that.
That's fine.
Okay, thank you. With that, again, it is under very difficult circumstances that I'm here. I do admit to the conduct as charged. I did so in the Florida bar proceedings to the extent that they challenged that. Once I committed the act which I was charged with, I cooperated in all respects possible, and I've continued to do so. The main reason I'm here today is merely to present and offer one point. And there's no surprise. I provided an argument in my answer. You pretty much can see that. I know counsel for the bar has already addressed that to some extent. But the evidence that I've provided shows a lifetime, a career of mine that I have devoted myself to reaching for high achievement. I've devoted it to service to the country, to other people. My resume provides a snapshot of that, and I'm not here to suggest, and I know the case law doesn't provide that a record of past achievements somehow is an excuse for an act of misconduct or acts of misconduct. I know it is not. I offer that only to show to you and present to you that this action on my part was an aberration, is an aberration. It's not who I am. To this day, I cannot explain why I made the choice I made. I had other options. I was in a bad place, having divorced in 2008 after being married for almost 14 years. Did everything I could to preserve that, to take care of my children and balance the financial demands that were placed upon me, not only post-divorce with child support and the like, but with the devastation to the Florida economy as a result of the housing bubble. In my resume, you may see a large part of my practice was devoted to real estate and construction law. And clients that I had built up prior to making partner were now coming to me for advice on dealing with debtors, asking for bankruptcy advice, which I didn't practice, so they obviously had to go elsewhere. So all of that culminated in a perfect storm, if you will, in February and March of 2011. Coincidentally, I had begun taking antidepressant medication, Reciprocal, in 2008.
I'm going to object to the extent that if he's going to testify, I think he needs to be sworn in.
Yeah, and here's where I think we're headed, and let me see if y'all agree. I believe that what your argument is or will be is that there's the similar discipline is going to work a grave misjustice, and possibly that the discipline would be different in the state of Texas. Okay, And if you are successful in either one of those, then that allows the board to impose some discipline. So I think we're going to need some information too, a little background perhaps. If we do find that you have carried your burden, something to help us come up with the appropriate orders that then comes within our jurisdiction. And that's going to also require some testimony. So I think it'd probably be better to offer that under oath and go ahead and offer your facts in that way. But also include okay, if we find you do carry your burden, then give us the background that's going to help us determine what an appropriate remedy is here.
I understand.
Okay. Why don't you go ahead and have the court reporter swear you in and continue offering your
From
testimony.
here is fine.
You can, yeah, you just be sworn, you can stand there.
Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Thank you. And I won't rehash what I was just doing. I probably should have asked to be sworn in because that's what I intended to do.
Were your statements earlier, now under oath, do you adopt those
I
statements?
do adopt those, yes. And I believe where I left off was describing antidepressant medication, which I had been prescribed in 2008. This was just prior to my divorce, which happened in March of that year. I continued on that medication without any interruptions, essentially through February of 2011. And it was at that time during a trip to Texas that I misplaced or lost my prescription, bottle, and essentially discontinued abruptly the medication that I was on. As I think the referee pointed out, and I will certainly testify, I was not incoherent. I was not unable to function or to think. It was maybe more difficult, but I was certainly not unaware of actions and potential consequences. I think in looking back, I maybe didn't care as much. I was depressed. I believe I characterized what I did as professional suicide. And that's still how I see it. I felt trapped financially with a number of many things. And at that time, I didn't think or appreciate the consequences. I think of myself as a bright person. There were things I could have done had I had a devious plan to be more, I don't know, I guess I did it openly, as if I wanted to get caught. I didn't hide anything, and I'm not saying that as a mitigation. I'm just still trying to grapple what I did and why. The point I'm trying to make to the board, as I mentioned in my answer, is this act on my part, which, to properly define it, I represented a client, I believe in 2003 or 2004, named Jerry Jackson, a young man who had been struck by an automobile in a pedestrian accident, broke both his legs, and I knew him through Adult Retarded Citizens of Marion County. I had been a member on that board for quite some time. I say I knew him. I was a board member at that institution, and as a result of that, I was told that there was someone that was in need, Jerry Jackson. They needed some advice. They were looking for someone to assist him through the post-accident process, and I met with him and assisted him through the insurance issues and whatnot, and obtaining a settlement from him, which was placed into to our firm's trust account. And it remained there for some time, primarily because he was on Social Security disability. He needed a special needs trust set up, which I didn't do. I sought assistance from other attorneys in Marion County that did that type of work, and there were only two, neither of which I could obtain pro bono services. So I was trying to preserve those funds for him. And of course, the irony is, some years later, I was the one who obviously had access to those and made a terrible decision to utilize those funds for my personal purposes. The amount that was taken in March was $5,000. I used it for some child support and also for tuition for my children. They were I was well behind on private school tuition, which I was required to pay as a result of my divorce, and I was trying to keep them in school. They were being threatened with being ejected, essentially, for lack of payment. I did, and I want you to know I did repay that money as soon as possible, less than a month later. Once I liquidated my 401k, I paid that money back in full. And again, the point I'm trying to make to the board, and I will be brief, is that if you look through my resume, you look through my career, this was a single incident. You know, bar council has listed the number of ways they charged it. It was me taking $5,000, a horrible violation of my client's trust, of the profession, and certainly not something I'm desperately not proud of. And I understand that disbarment is and was, and I respect that decision, which is why I did not challenge it in the Supreme Court. The reason I'm here today is mainly to present to you the only argument that I have, and that is, if you review the cases that I presented under Exhibit 10, they all involve instances where the referee and subsequently the Florida Supreme Court imposed a sanction of suspension of some period of time, with or without conditions. All those cases involved attorneys who had committed an act of misconduct, misappropriation in every case, involving one incident of misconduct. They had good records. They had mitigating evidence or testimony and evidence to support their case. And I believe and still believe today that my case more appropriately falls within those. On the other hand, the referee considered cases, there were 4 of them, which are listed under 14 of my exhibits, that involved cases of misconduct with misappropriation. But uniquely, in all of those cases, it involved instances of multiple acts of misappropriation, either several occasions or misappropriation over a period of years. And I'm not saying the amount matters, it's the number of times that it occurred. In all of those cases, Valentine Miller was from 2004 to 2006. That attorney dipped into her trust account and used funds inappropriately, a long period of time. Brownstein is the other case from 2007. That individual was charged and brought before the court for misappropriating funds in excess of $20,000 on an instant, but during that proceeding he testified that he had done so numerous times before, both in the 1990s and again in 2000 to 2004. In the last case, Travis also involved an audit which showed between the years of 1996 and 1997 an attorney had used funds in excess of $35,000 of the client's money. I am not in any way saying that what I did pales in comparison. Taking clients' money is the worst thing that could be done. I recognize that. I did it once. I will never do it again. I did it at a time, coincidentally, when I had gone off medication, which is not advised, resulted in lack of clear thinking, and as a result of that, I had asked that at least that be brought into consideration. Texas has also, this board has also, in the case of, I believe it's Brown that I provided, awarded sanctions in the form of suspension for misappropriation of funds. It's not unheard of. And I recognize the burden I carry is quite high. Clear and convincing evidence. I've practiced appellate law. I know what that is. That's a virtual, I'm wasting my time. But I'm not wasting my time. I'm here because I need to be here. I need to see this through. And I respect whatever decision you reach, and I understand the mountain that I have to struggle through to prove that what happened in Florida somehow is a grave injustice. I did not find any definition of that, but the term alone, grave, is very serious and very significant. Or that Texas would not impose similar punishment. There are plenty of cases where misappropriation of funds would result in that. I only ask that you consider what I've done, consider the results of the Florida bar case, and consider whether or not I have anything to offer short term. I'm really just trying to give you a reason, even a small one, to give me a second chance. That's all. That's why I'm here. Like many that face these disciplinary proceedings, I consider it very, very strongly not even coming. It's very intimidating. It's very difficult to be here and face my mistakes. But I have offered and proposed a sanction which I believe would be good for me and would allow me to help those. That's really why I wanted to practice law, was to serve others. The best job I had, and I'll say this to anybody, the best job I had was doing legal assistance in the military for a full year. I went in that job thinking I was being put out to pasture because I was being strong-armed into deploying overseas, which was something I didn't want to do for reasons that don't matter. But I ended up helping people. They were at the door all day. I loved that work. I would like to do that again, which is why I've proposed and asked for the opportunity to do that. I'm not sure the board has ever done it. I'm not sure that you would even consider it. There may be reasons not to, but I have suggested a suspension for whatever period of time you deem appropriate, and I would welcome the opportunity to try to restore to our profession what I've taken away, to help those in need, like Jerry Jackson, through pro bono service. I picked 300 hours a year. I suggested that, and it's a somewhat arbitrary number, but that's 8 hours every Saturday for a year, roughly. That's how I came up with it. And I said 2 years. I'll do 3. I'll do 5. I just want a chance to prove myself. And again, I'm not asking for an opportunity to practice law for profit. I don't want that. I will make do and I will make it work. I have not represented clients for profit since coming here, and I don't intend to do it again. And I welcome the opportunity, like I said, to do pro bono. There are opportunities for me, and there's definitely a need in this economy, and that's all I'm asking. I'm not sure that you feel able to do that, but I respect your decision. I thank you for your time, and if there are any questions, I'll be happy to answer those.
Why don't we do this? Why don't you go ahead and take the witness chair and allow
Yes,
Mr. Berry
certainly.
to cross-examine you on anything she might have. Then I'm sure we'll have some questions for you.
I do.
Go ahead, Mr. Berry.
Mr. Gifford, I believe you testified that you didn't hide anything, is that correct?
I may have used those terms, yes.
And yet, didn't you tell your law partner, and I think this is in the affidavit that the board admitted, that when they first confronted you with this, you told them that the checks had been deposited into bank accounts, isn't that correct?
I'd have to look at the affidavit. I will say the checks, there were 2 checks written, and yes, one of those was deposited in I believe it was a money market account, and the second check was negotiated to me.
Okay, may I approach?
Yes.
Could you please read number 5?
Yes. Says this is affidavit from Mr. Gilligan. Quote, "My partners and I were uncomfortable with the transaction because we did not believe it was appropriate to have placed client funds into an account in the name of a firm member. Thus we continue." I'm sorry, I read the wrong one. Number 5, on March 30th, 2011, Mr. King and I briefly discussed the transaction with Mr. Gifford, who had indicated that all the proceeds of the checks had been deposited into an account for the benefit of the client.
That wasn't true, was it? You hadn't deposited?
No, I had negotiated $5,000, the check for $5,000 to myself. That was the misappropriation.
Okay. Now, the individual, Mr. Jackson, was retarded, is that correct?
He had an IQ, I believe, of 90. He was independent, living alone. He had a social worker. So when you use the term retarded, there's all different spectrums of that in terms of an individual's capability. And again, his IQ was 90. He lived independently with the assistance of a social worker or caseworker, if you will.
Okay, so he had a mental handicap, though?
Yes, he did.
And he was also legally blind?
He was not legally blind, well, after the accident, yes.
Okay. So at the time that you signed him up as a client, he was legally blind, correct?
He had suffered an injury to his eye, yes. So I don't believe he had been determined at that time what his vision impairment was, but
And he did not call you, did he?
he did not.
Okay.
No.
You testified that you tried to find someone to create the documents on a pro bono basis, on a special needs trust or guardianship or whatever is the appropriate mechanism for that in Florida.
Yes,
You didn't represent him on a pro bono basis, did you?
I did not, no.
In fact, your fee was close to $16,000 on this,
It was.
approximately?
Well, yes, it was a third of the total recovery.
And would you agree that you probably could have gotten a special needs trust done for under $2,000?
Yes, with the right attorney, sure.
Okay. And yet you took more than that, correct?
The misappropriation was $5,000, yes.
$5,000, okay. And I believe, at the time you took the money, you had already remarried, is that correct?
Yes,
Okay. So and how long were you off the medication?
the trip to Texas was in the latter part of February, probably the 20th, I believe. And coincidentally, it was a trip to, my then wife was from Texas. I was coming here to help her move to Florida. So probably about 3 weeks by the time the misappropriation happened.
Okay. And none of your law partners, you continued to work?
During that time?
Yes.
Yes.
And no one noticed any problems with your functioning at work?
Are you asking me to speculate? Did they,
Oh,
no
no, I
one
mean,
approached me. Did
I mean,
they,
the
there were
referee-
people, you're asking me, there were people that noticed.
The referee's report stated, I believe, that no one in your law firm, or whoever testified for you at that trial from your law firm, had noticed there were any problems with your work during that time period. Would that be a fair statement?
No, well, yes, and it wouldn't surprise me. I was a partner, nobody supervised my work.
And you didn't report any problems to the physician when you saw him to get your prescription refilled either, did you?
I went to him to get the prescription refilled,
Correct.
and the reason to refill it was because of the problems I was having. It's inappropriate to say no one testified there were problems. My ex-wife testified at the hearing and said that I was more argumentative, more difficult.
I'm going to object to hearsay on that.
You had already asked him if anybody testified as to noticing, so I'm gonna let him go ahead and
I
answer.
believe I asked him about his law partner, but,
I'm gonna overrule objection.
okay. In fact, isn't it true that the only thing that you reported to the doctor as a result of not taking your medication was some irritability?
I believe that's what his report said, yes.
Okay. And are you trying to tell the board that you took the client funds because you were off your medication?
No,
Okay. Is that, you're not trying to blame this on not taking your medication?
absolutely not.
The funds that were were deposited into your firm's trust account during the, what, approximately 6 years from the time the case settled?
I believe so.
They earned no interest for your client, did they?
They didn't.
And you didn't volunteer or reimburse the client for any interest that those funds could have
I have
earned
not,
during
no.
that period of time, did you?
No.
And your firm actually repaid the amount to the client originally, is that correct?
The firm restored the funds to the trust account, I believe on April 2nd, 3rd, or 4th, immediately after finding out what had happened. And then I repaid the firm, I believe as indicated in the exhibit, on April 27th, which was,
That was after the bar's investigation had been begun?
it was after my law firm followed their responsibilities by reporting my misconduct. So to that extent, the bar had been notified.
It was also after they had taken your deposition, is that correct?
That I don't recall. I'm not sure the dates. If that's true, I just know I repaid it as soon as I had, immediately after I got the funds from my 401k.
See, your deposition was taken, I believe, on April the 12th of 2011.
Okay, then yes, it was several weeks after the deposition had been taken.
Okay.
Again, as soon as I had the funds available, I liquidated my 401k so that I could pay that money, and I immediately paid it right after that.
Was there a reason you couldn't liquidate your 401k or get the funds out of that prior to that time?
I had submitted the necessary paperwork through my office, and it was as soon as the check came. I'm not sure why it was delayed, but I immediately asked for those funds, and it took.
When you say immediately, when did you submit the paperwork?
Well, I was terminated on April 1st, and I believe within the next week I requested the funds. Our, what do you call it, 401k manager was in Jacksonville, and, well, that's the time frame.
I'll pass the witness.
Why don't you go ahead and retake the lectern so we can, it's kind of hard to see the witness.
I understand. Yes, sir.
And any questions? Ray, you look like you're about to.
Well, I was wondering, Mr. Berry, whose affidavit were you questioning him from, please?
That's the affidavit of one of his law partners that was you all admitted is, I think, Exhibit 2, or I don't know what number you all gave it. It was the one I think he had designated as Exhibit 2. It's of Patrick G. Gilligan.
Thank you.
Any questions for the witness? Let me ask you this. You took a third of the total recovery as a fee, correct?
Yes, approximately.
Okay. After that time, were there any other charges against that for work that you did?
There was a $500 charge. One of the associates in the firm had prepared pleadings for the Special Needs Trust, and I believe that $500 had been charged out of the account. There were other charges, but they weren't firm-related. During the 6-year period of time, Mr. Jackson had requested funds for furniture. He had moved into an apartment with a roommate, so they needed furniture, and that happened, I think, probably 3 occasions. But those were disbursements made directly to him that my legal assistant took care of. And then the $500, I believe, was also reinstated or reimbursed by the law firm, by Gilligan King Gooding.
Okay. When was the charge for the paperwork for a special needs trust? When was that work done?
I honestly don't recall
In
the year.
proximity to time, to the time that you took the money out?
It
I mean,
was-
it a year before, 2 years?
It was probably a year before. The money had been in the trust account way too long, and part of the reason, well, the interest in getting the money out of there was to get it to gain interest. And obviously that presented an opportunity that I took advantage of. But it was about a year before my associate, or one of the associates in the firm, I asked him to look into it, try and prepare pleadings so we could try to do that work.
Why wasn't that completed?
The paperwork was not in a form that was was really usable. I mean, it's maybe a very easy process. I'm sure it is. It's not an area of law that I practice in, and our associate, no one at our firm did as well. So it was work that needed to be redone totally, and it just never got done.
Okay. Tell me a little bit about the Florida system. Is there a presumption in Florida of disbarment under the standards?
There is, for certain acts of misconduct, there is a presumption.
Okay.
One of those being misappropriation.
And I'm really asking you to kind of help us understand the differences between Florida and Texas.
There is a presumption of disbarment for misappropriation. However, any of those cases I presented to you will acknowledge, and the Florida Supreme Court has acknowledged, that presumption may be overcome by mitigating evidence, such as what I presented to the Florida bar and to the referee, and what was presented in all those cases that I cited to you. Mitigating evidence, there's a long list of things that can be presented, past record, reimbursement, remorse, any number of things. And in fact, that presumption has been or was overcome in a number of cases. And I had hoped that would be the case in my instance. The difficulty I think that I had is we presented written arguments to the referee. Much like I did here, I presented all the cases that I was to rely on. I did not get a chance to rebut or respond to the cases submitted by the counsel for the Florida bar. And obviously, I could have done so at a higher level at this Florida Supreme Court, but I respect the decision, and the challenge there is much like it is here. It's very difficult to overcome a deference to a referee's report, and I recognize that.
So in the Florida grievance system, you don't have a hearing, you just submit written documentation?
No, I'm sorry, there was a hearing. The hearing was a lengthy one, and at the end of the day, the district court judge, who was acting as a referee, rather than listening to argument after the presentation of evidence, and keep in mind, it wasn't a hearing to determine guilt or innocence. I'd acknowledged my role and pled guilty. The sole purpose of that hearing before the referee was to determine the appropriate sanction. And at the end of that, she just said, submit written arguments within 5 or 10 days, which we both did. And then she made a decision based on that, and basically signed the proposed order that was submitted by the Florida bar.
Okay. Help us a little bit with why you believe the identical discipline would work a grave injustice.
Well, again, as I mentioned in my comments earlier, I did not find in Texas case law there may be some definition of what a grave injustice is. I suppose I could have looked at statutory construction or something like that to find out how that is defined. Obviously, from a personal perspective, it would be very easy for me to say it's a grave injustice, but I think that's a bit shallow. The main reason and the only argument I have is what I've made, is that the weight of Florida case law suggests that perhaps I should have had a lesser punishment. Not because I deserved it, just because my record of achievement, my record of service for 44 years I'm not perfect, but it was certainly unblemished. I never had a disciplinary action taken against me. I never had a complaint that it wasn't resolved or even addressed with a client. Never got to that level, and I had a lot that I had accomplished and a lot of mitigating evidence one of those, again, as I've testified here, I don't propose to tell you that the medication made me do it. It didn't. My mental state, the circumstances led to me not making a decision that I knew was wrong. If I could take it back, I would. I can't. And is that a grave injustice? I don't know. I can't pull a case out and tell you, look at this. I wish I could. I'm just here as a person. I'm very sorry for what I did, not just to my client, to the people that trusted me, to family. I mean, actions have a ripple effect, and this one has been very significant. That's a sympathy argument, I know. Legal arguments, I don't know that I have one. I'll be honest with you, I'm not here to argue. I'm not here to make this a long, drawn-out process. I'm just here because I feel like I need to be here, whether it's for closure or, again, just to ask for a chance. That's it.
One of the other things that we are tasked to look at is determine whether the misconduct established in Florida, which would be you're taking your client's money, warrants a substantially different discipline in Texas.
Right.
Is it your contention that in Texas, if you take your client's money, that you get a substantially different discipline?
No, it's not. I mean, I think misappropriation in most cases, most courts, most states have held that's the worst thing a lawyer can do. It makes sense. There are certainly other offenses that lawyers commit, but I guess that one is more egregious because it affects the client and the profession, but the client, violates client trust. I do know, as I mentioned with the case that I presented, is that it appears that Texas case law does acknowledge that in the appropriate circumstances, these disciplinary cases, from what I understand, are case-by-case basis. And as with the case Brown that I presented to you, that gentleman misappropriated a substantial amount of money. I believe it was all repaid, and he was suspended for a period of time. So it is not my understanding that disbarment is mandatory. It is perhaps presumed to be appropriate and should be, but in appropriate cases, on a case basis, suspension has been awarded.
Anybody have any other questions or things for Mr. Gifford? Ms. DeBerry, any further questions for the witness?
I don't, Your Honor.
Okay.
Thank you.
Do y'all want to make a brief close or leave it at that?
I do.
Okay.
Disbarment is an appropriate sanction for an attorney who steals their client's money. In this case, the referee considered both mitigating and aggravating factors that were present in the case. Emotional problems, he claimed the depression as a result of a divorce, but the referee found that he'd already remarried, and that indicated to the referee that he'd moved on with his life. The psychiatrist testified, contrary to the internet research that Mr. Gifford had done, that there was no causal connection between not taking the meds and the misconduct. Aggravating factors that are compelling in this case are particularly the vulnerability of the client. The fact that the client was mentally handicapped, was legally blind. There was also indication in the report that the client had never contacted Mr. Gifford. He went and signed the client up within 30 days of the accident. He took his fee. He took a full 1/3 fee from this client. And there was also some indication that he had indicated to the brother that he was going to do this pro bono. He did not. And yet, when it came time for a special needs trust, he never got it created for 6 years. because he couldn't get that done pro bono. Out of his 16,000 fee, it would not have taken that much to even pay for it himself, if that was his true concern, was maintaining funds for the client. As a legal profession, we're very fortunate that we have the ability to police our own. But we have a duty to maintain respect for the legal profession. And it's a serious matter when an attorney intentionally misapplies, misappropriates, steals client funds. It's a privilege to be a lawyer. It's a privilege most of us have worked very hard to get. It's a privilege most of us work very hard to keep. When an attorney violates the rules, especially takes client funds, it's a privilege they don't deserve to keep. Respectfully request that this board enter a judgment disbarring Mr. Gifford. Thank you.
Mr. Gifford?
I just want to thank you all for your time and attention. I know it took longer than we expected, but I respect the job you're doing, and thank you for your time.
We appreciate your appearing before us. I know it's not an easy thing, and we take it very seriously, so we appreciate your attendance. Okay. We are adjourned in.